All right, hello everyone. My name is Christian Jorgensen. I'm one of the legal advisors in IHL at the American Red Cross National Headquarters. Today we're joined by Dr. Asaf Lubin and Dr. Russell Buchan to discuss the topic of the right to privacy during armed conflict. We're really happy to have both of these renowned scholars and academics on this topic to speak with us because they're the recent co-editors for the publication, The Right to Privacy and Data Protection During Armed Conflict. I'll be dropping a link to where you can read that publication in its entirety as it's open source in the chat during the presentation itself. But as I mentioned, our speakers are Dr. Russell Buchan, who's currently a senior lecturer at the University of Sheffield, located in the UK, and Dr. Asaf Lubin, who's an associate professor of law at Indiana University Maurer School of Law. So before passing the virtual floor over to our speakers, I would like to encourage all of those in attendance to please place any questions you have in the chat or Q&A, as we really want this event to be discussion-based. So your questions and just topics that you want to hear more about are going to be gratefully welcomed by our speakers. So with that, I'll pass it over to Dr. Lubin.
Thank you so much for the invitation. I think I speak for both myself and Russell when we say we're really grateful to be here and for the opportunity to present this book to you. As was already alluded to, we are envisioning this as a conversation and a discussion about what we think are really important topics in the area of emerging technologies and armed conflict. And so we'll keep our presentation relatively brief, not more than 15 minutes. And so at the outset, let me just provide some examples of what had motivated us to launch on this research project. Just in the context of the situation in Ukraine, we've now witnessed significant impact on data protection, privacy, cybersecurity in the context of armed conflict. Examples include the capturing of detainees and then the use of social media platforms to embarrass them and or to reveal information about them. But also the use of what some call the commercial space war, the use of commercial satellites in the context of the collection of information and evidence as part of armed activities or as part of war crime documentation, as well as the use of user-generated evidence on the ground. So across the board, we're seeing utilizations that were not once conceived of when the Geneva Conventions and additional protocols were created. But it's not just in the context of armed conflict, it's really in the context of military activity as a whole. And in our conversations with military professionals, we've learned that there's now real questions about the usage of various smartphones and other technological solutions and their implications on military activities. So the examples on the screen right now come from the US, and they include the ways by which the use of dating apps or Fitbits or other kinds of tracking technologies could result in providing a lot of information to the adversary about locations of sensitive sites or usage of particular technologies. And so against that, some militaries are suggesting the usage of certain technologies that could be privacy intruding, or certain solutions that could interfere with the right to freedom of expression of certain military employees. And so in that context, the questions on how the rights to privacy, data protection, and so on are triggered, not just in the context of the enemy or the civilians in the foreign territory, but also your own personnel. And perhaps the last example has to do with the advancement of the AI arms race. When we in the academic circles talk about AI in war, oftentimes conversations shift to autonomous weapon systems, but really the conversation should be far broader than that. AI is now part and parcel of every aspect of the military machine, from intelligence, surveillance, and reconnaissance to various forms of logistical support activity, all the way to the centralization of command and control military structures or cyber defensive and offensive activities. And so across the board, AI, which is a data collection and data generation machine, is being utilized, and that triggers a lot of never seen before questions around privacy and data protection as these technologies take hold. So against this background, what I think is fascinating is the fact that it is not that the Geneva Conventions are completely silent. While these documents were drafted at a period that predates the internet and predates many of these technologies, there are provisions that you can turn to try and find some answers to the questions posed by the usage of these technologies. And the authors in the book look at those. So for example, we have a chapter by Buchan that looks at weapons review, Article 36 of the First Additional Protocol, to ask how the advancement of new technologies utilized by the military could be grounded in its review with the analysis of rights to privacy and data protection baked into the review process. Or we might turn to the prohibition on pillage of the personal belongings of a person deprived of their liberty to try and find answers about certain gathering of information. And certainly in the context of the rights of detainees, there are certain provisions that relate to special surveillance and other rules about the detainees in times of armed conflict. But at the same time, obviously, these conventions were not drafted with these technologies in mind. And so in order to rely on IHL as it stands, you'll need to engage in analogy and extension, and sometimes those analogies and extension fall short. And I think that many of our the authors in the book have demonstrated the limits of existing IHL in trying to regulate these technologies. So against this backdrop, there is a body that is out there, it's human rights law, and within it, the right to privacy enshrined in most international conventions, which includes a set of principles that have now been enumerated by the European Court of Human Rights, the Inter-American Commission on Human Rights, the Human Rights Committee, that establish when states can engage in certain privacy intruding practices. They include such principles as legality and proportionality and necessity and access to remedy. Similarly, there's an emerging right to data protection. Some would even argue that it's a regional customary right in Europe that might be slowly expanding beyond Europe. It too has had now a body of jurisprudence around it with a set of principles that could be applied in the context of various practices that intrude on data. And they include, for example, obligations to limit storage collection or limit collection and storage for certain purposes that are deemed lawful, or to engage in various accountability mechanism, or to ensure integrity, which triggers cybersecurity issues and confidentiality of the data. But of course, there's problems with human rights law too. And I think that many of the authors in the book demonstrate that. That is, both in the regard to the extraterritorial application of these human rights, the concurrent application in times of armed conflict, which just manifests in a new way in the context of privacy and cybersecurity, and with regards to the scope of application. So is it a treaty right or is it a customary right? How do we trigger it when most of the entities involved are not only states, but also businesses contracting with militaries? And various questions of interpretation about what it means in particular circumstances. On top of that, there's obviously the issue of limitations and derogations. These rights are not absolute, and they certainly can be derogated from in times of emergency. And so questions of what is a state of emergency and how it applies in these contexts obviously is triggered as well. And of course, at the end, there's also the question of whether individuals have a right of action standing before courts to bring these human rights in practice. And so against this background, human rights law might offer a solution in certain areas, is certainly opening a conversation, but it could also be that human rights law falls short too. And I think that in our conversations with colleagues with military professional on the grounds, what we're witnessing is that this is the starting point for a conversation, and everyone agrees for the need. And we're hoping that the book would serve as a mapping, a canvassing exercise of all the various issues and identifying where law works and where law is silent or can be advanced either through human rights law or through interpretations of IHL. I'll end my portion with one last thing, and that is to say that there is also a set of market realities and technological infrastructures that are undergirding all of this. And so where law stops short, markets kick in. And there's a lot of questions on how do we regulate markets and how do we ensure data protection by design and by code as a form of preventing the need to turn to law as a residual mechanism to respond to problems within the markets, within the technology, after it has already been developed and deployed. And so there's a lot of conversation that happens with the industry, not just with the military, as was custom in other areas of IHL. Right. So that is kind of the nutshell of kind of the introduction into the book. And I'll turn it to Russell now to introduce you to some of the chapters that the book covers.
Thank you, Asaf, and also thank you to Christian and to the wider American Red Cross for putting this event together. Just let me start by saying that this isn't a normal academic book that's designed to target specifically academics and specifically researchers. When Asaf and I were putting the book together, we worked really hard to make sure that not just the topics of the book would appeal to a wide number of stakeholders, but also the way in which the chapters are written and also the authors that were writing the chapters was very keen to make sure that the final product, as I say, would appeal to the widest possible audience. So I think those involved in the humanitarian communities, such as the American Red Cross, will find those chapters both interesting and relevant, but also accessible, readable, and useful in their day-to-day work. So you can see that Asaf's helpfully put up a slide there of giving an overview of the contents of the book. But let me just say a few more words about that, because I think it's important so that you can get a real sense of what the book is doing and where the book is going. So the book is split into 4 parts, and they cut across different themes. The book begins with part 1, which explores the extent to which various regimes of international humanitarian law protect the right to digital privacy and data protection. And that part kicks off with a chapter by Mary Ellen O'Connell, who advances the argument that the protection afforded by international law to personal data is the same during times of armed conflict as it is during times of peace. And in chapter 2, which Asaf has alluded to already, Tal Miram and Yuval Shani zero in on the weapons review obligation contained in Article 36 of Additional Protocol 1, arguing that it requires states parties to integrate privacy concerns into their evaluation of new and emerging technologies. In chapter 3, Laurie Blanc and Eric Talbot Jensen examine the extent to which IHL governs the seizure, destruction, and requisition of data during times of armed conflict. In chapter 4, Jacqueline van der Velde assesses the extent to which the law of neutrality requires neutral states to monitor and prevent companies located within their jurisdictions from transferring data to parties to armed conflicts in breach of the rights to privacy and data protection. In chapter 5, and perhaps a chapter that's gaining increasing salience in the context of Ukraine, Omar Shababi explores how the law of occupation, and in particular the obligations it imposes upon occupying powers, how they can be progressively interpreted to protect the right to digital privacy and data protection. In chapter 6, Emily Crawford, also touching on a contemporary issue in the context of Ukraine, examines the privacy-related rights of prisoners of war in the digital age, and in particular identifies the type of data that detaining powers can collect from prisoners of war. In part 2 of the collection, we considered the impact of surveillance technologies on the enjoyment of digital rights. And in chapter 7, Leah West explores the legal obligations arising during armed conflict that limit the use of facial recognition technology by belligerent parties. In chapter 8, Eliza Watt examines the impact of sustained drone surveillance on non-combatants in war zones and analyzes the legal constraints placed by international humanitarian law and international human rights law on this practice. In chapter 9, Tara Davenport analyzes the international legal rules that apply when parties to armed conflicts collect data stored on or passing through underwater sea cables. Part 3 of this collection examines the obligation of militaries and humanitarian organizations when it comes to the protection of digital rights. In chapter 10, Tim Cochrane explores the potential of individuals to obtain personal data from military agencies under the legal regimes of several states, namely Australia, Canada, New Zealand, and the United Kingdom. In chapter 11, Deborah Hussein-Coriel focuses on data sharing within military, multilateral military operations. And in chapter 12, our very own Asaf Lubin, and perhaps a chapter that's going to be of particular interest to the humanitarian community, examines the obligations of international organizations to protect data in the context of their humanitarian action and uses the ICRC as a case study. In part 4, Finally, chapter 13, Christina Hellwig examines the role of the right to privacy in the investigation and prosecution of international crimes. In chapter 14, Yael Ronen considers the right to be forgotten. That is the right of individuals to have digitalized personal information removed from the public sphere. And finally, in chapter 15, Amir Kahane proposes a right not to be forgotten, to contrast this quite nicely with Yael's chapter, which, in order to protect digital identities, would place a moratorium on private tech companies and prevent them from denying individuals caught up in humanitarian crises access to their online accounts. So that's a wrap for the book. As Christian said, it's open access, and I think he's given you the link to the book. So please go up and use it, and we're interested in any thoughts, comments, or questions or concerns that you may have.
Well, thank you both again for joining us today. I do have some questions, some that the three of us have talked about before, at least to get us started. And one of them is about how, immediacy of an issue or importance, these are often the foundation of what parties focus their energy on in conflict, but also everything that surrounds conflict, both politics and law. And part of that is because resources are limited, whether they be certain means or they be manpower. So you have to focus on what you deem to be most important. And so I guess the question that we partly discussed prior to today's presentation is the right to privacy and data protection that important during times of armed conflict? Some people might say there's more important issues to focus our energy and to use our resources and capacities on, for example, the potential shelling of the nuclear plant in Ukraine or violence against civilians. So how would you respond to that? Why is this a focal point of what our energy and resources should be going on when those things are limited?
I'm happy to go first. So that's one of the common questions that we get with this project. And it does seem odd when more visceral attacks on the body happen to try and focus on dignitary rights, on issues that relate to the spirit and not the body. But there's multiple responses on the value of recognizing and addressing those concerns as well. And one, perhaps the most immediate, is that rights to privacy and data protection could be a linchpin for other human rights abuses or other war crimes or attacks in violation of the laws of war. And so one example of that happened in Afghanistan. Recall that the rushed departure from Afghanistan had resulted in an inability to properly defend the identities of individuals who worked with coalition forces in Afghanistan, including individuals whose data was collected and shared either publicly on websites. So in the late days following the departure, Canadian State Department, Ministry of Foreign Affairs had to delete information on its website of individuals out of fear that the Taliban forces would capture them and then utilize that information against them. The same also is true, and Leah West talks about it in her chapter with regards to various collection tools that were utilized to collect retina scans and fingerprints and so on by forces on the ground that were left behind, and then now were at the possession of the Taliban, who could use it for detention, capturing, harassment, and even in certain cases killing those who it deems enemies of the new regime out of collaboration with the enemy. And so that is just a visceral example of where privacy and data protections, their protection is necessary if we care about those other values that people often defend. But on top of that, I think that we live in a different world today than we once did, and that everything is extremely interconnected and interlinked in ways that it is impossible to disentangle the collection efforts of militaries. Think about surveillance. The collection efforts of militaries are then translated into targeting operations on the ground. And so I have a separate article that I wrote called The Reasonable Intelligence Agency, where I talk about we cannot just focus on targeting so much if we don't understand all the behind the scenes that happens in the intelligence side leading up to the targeting. And so we now need to start talking about informational operations and the rules that govern them, because they are directly linked to the other IHL issues that we care about. That would be my start of an answer, but this is a broad question. I'm sure Russell has other thoughts.
I would countenance everything you say, Asaf, but I would say perhaps more theoretically, and this is explored in the book as well, in some of the authors get to grips with this, which is just the close proximity between the protection of the right to data privacy and human dignity. I mean, I think we could perhaps all agree that human dignity is one of the lofty goals of the international community. And of course, human dignity is more susceptible to violation in times of armed conflict. So if we accept that the right to privacy and human dignity are inextricably linked, then it's quite natural for us to want that value, that right, that human right, that fundamental human right to be adequately protected. And of course, we think that stopping shelling of civilians, stopping shelling of nuclear plants is really important. But if you look to the international humanitarian law textbooks, the famous international humanitarian law textbooks, you'll see a lot written on that. And you can probably get some fairly conclusive, definitive answers to those questions. If you look to those same textbooks to see how the right to privacy, in particular data privacy, is protected during armed conflict, I'm fairly sure, I'm looking at my library on the floor now, that they'll provide you with very, very few answers. And that's why we did this book, to try to give, for example, the humanitarian community greater insights as to how international law, human rights law, humanitarian law protect that really important right. And if it doesn't protect that right, then we need to expose that because that can enable developments in positive international law to occur and better protect those rights.
And if I may just say one more thing, it's just, I don't want people to assume that what we're talking about here is purely theoretical and detached from the real life decision-making that are happening on the ground right now in militaries around the world. In our conversations around this book, we have met with various military professionals who have told us, especially, for example, in the context of coalition warfare, where part of the struggles that they are now facing is that as part of their coalition activities, they have shared databases. Those databases require multiple countries to share data to one system. And each country has its own data protection national laws. And there's a hard question, especially where, say, Germany or the Netherlands have made data protection rules apply to their military activity. Now, what do you do about that when the US has less stringent data protection regimes, and there's a worry that sharing German data with American counterparts will now infringe on those rules? And so relying on international standardization as a tool to enhance the capacity of coalition activity has now becomes a fundamental issue for these militaries. And so they're seeking these questions and looking to find answers to them in real time as we speak. And for the most part are doing so in isolation from a public debate, which we are hoping to start.
Yeah, that's exactly what our department really tries to do, is start the conversation on things that need to happen, because oftentimes we get bogged down with things where the conversation's already been happening on certain topics for a long time. And in order for things to progress, you have to move that conversation forward and not just keep talking about the same things. We did get one question, well, two questions, but the first one is about access to the book. I'm putting that link in the chat again. So then our second question is a perspective one for both of you, and it's about reports of Russian filtration camps and the reported practice of arguably invasive techniques used on detainees. They add, although we don't have all the facts, what concerns do these sorts of reports raise from your perspective? If you're able to speak on that.
Yep, I can say a few words. So there is a chapter in the book by Emily Crawford on the treatment of prisoners of war, and I think for me it's one of the most provocative but important chapters in the book. So of course, international humanitarian law protects prisoners of war. We know that, but we're perhaps more familiar with understanding whether that protects them from certain types of physical harm. As opposed to the extent to which they're surveilled, what information can be taken from them, and how that information can be taken from them. So in Emily's chapter, she really digs down into those rules and tries to demarcate the limits to which detaining powers can interact with prisoners of war. Of course, detaining powers can take certain information from detainees, can impose certain limits on their behavior, and can surveil them to a certain extent. But the question is, where are the limits of those capabilities under international humanitarian law, and indeed whether international human rights law can be engaged there to provide additional protections. So I would encourage the person asking that question to look to Emily's chapter. I mean, there's no clear-cut answers, I'm afraid, but it really is a case of looking at the rules, moving around the rules, interpreting the rules in order to gauge the extent of the protection.
And let me use this question as a jumping off point to another aspect of the Russian-Ukraine that has recently made the news. And so on August 9th, Adam Seterino from the New York Times published an article titled "How Russia Took Over Ukraine's Internet in Occupied Territories." And in it, he's discussing the way internet traffic in various occupied territories across Ukraine is being diverted through Russia, and they're censored. When you think about certain reports that Russia is intending to engage in various forms of election and annexation, referendums and annexation in those occupied territories, the use of misinformation, disinformation, censorship would play a massive role in those efforts. And once again, we have this intersectionality between a traditional body of law in IHL, occupation law, and emerging technologies, and hard questions about what rules constrain, if any, this form of Russian activity. And I'll say on that sometimes our existing body of human rights law might too not be sufficient. That is to say, our body of human rights law is an old enterprise as well. Going back to the Universal Declaration of Human Rights and then to the International Covenant and the European Convention. These are 1940s, 50s, 60s documents. And so when we imagine them in 2022, there have been human rights scholars who have been calling for the emergence of new digital rights and whether or not all of them are captured by traditional human rights. In this case, including in the context of the right to free internet. And so there's hard questions to be asked and to try and answer, but the reality is that things are happening on the ground as we speak, and that understanding that these questions require a more interdisciplinary and multi-conceptualized lens through which to think about them is precisely the motivation for this book.
Excellent. We have another question in the chat, and it was something I was going to touch on later. Because there's specifically a chapter in the book that focuses on, the obligations for international organizations, and the American Red Cross is a part of a larger international movement, made of lots of different organizations, some of which constitute, the definition of an international non-governmental organization with the ICRC. So the question is, what ways of the rights to privacy and data collection do we need to consider as members of those organizations during these situations? And the person adds, and I think it's actually a good thing to add, both on the ground, so maybe that has to do with the collection of data, but then also virtual, and that could be someone receiving that data somewhere else. So Asaf, I know you wrote the chapter on that book, but Russell, I've also been in a room with you where you're talking on the very subject of that. So feel free, both of you, to chime in on what we need to consider as well and to remember.
So we're thrilled this question came about, because obviously both of us have been thinking a lot about it, and also have been thinking in ways that some have found provocative about that. So at the outset, let me just say that many organizations, including the Red Cross and including other humanitarian organizations, both in the civil society space and within the UN framework, have done really good work in setting out best practices, in developing guidebooks and guidelines and frameworks that they develop internally and on the basis of a voluntary framework that they are hoping that others will follow. And so really, the ICRC has been in the lead on that, going back to its handbook in 2015. Other bodies like the UN High Commissioner for Refugees has produced great work on that, as well as more broadly within the UN, the Global Pulse Initiative has set out particular suggestions and guidelines on how to collect data, but also how to engage with procurement efforts? How do you buy access to online cloud providers, and how do you choose your cloud providers, or internet connected devices, and so on and so forth? My concern is that so much of that has been done in a voluntary effort, and in part done explicitly by stating that we as an international organizations are not bound by any one jurisdiction, and therefore are not bound by data protection rules, including when there's a particular breach of data, we are not bound to go to their data protection authorities and A, report it, and B, be subject to their enforcement mechanisms, because we are immune to those activities. And at the same time, also alluding to, though not explicitly saying so, always, the human rights law is applicable to states and not to international organizations as such, and therefore we are not bound by any human rights law that applies, because it is not officially applicable to us. The problem and that is the core of the chapter. The chapter is trying to suggest that that is not the right approach, if only for advocacy purposes. That if we are ever to persuade states that they should be bound by these sorts of rules, the kind of organizations that are at the forefront of this kind of work, and what is more at the forefront of that than the ICRC, need to recognize the legal nature of the obligations as a way of setting the norm for the states to follow. That has been taken, so as I said, that was controversial, and I understand that it might not be the view shared by all. But more broadly, I will tell you that all these organizations are, and by the way, it's not just international humanitarian organizations, it's also international courts, so, and other fact-finding mission of the UN. So all these bodies who are involved in the various aspects of the USIN and Jus Post Bellum are asking themselves, how do I collect data? How do I witness testimony? How do I rely on user-generated evidence in ways that ensure the integrity and protection of that data, especially when I'm sharing that information with third parties, or relying on commercial actors to help me sort that data out and manage that data? And where does law should step in, and enforcement mechanisms to ensure that when abuses happen, we know the ICRC has recently been a subject of a hack. So certainly things could happen wherein should there be enforcement and accountability that is not only internal to the organization, but also external to ensure greater oversight and legitimacy to the work of the agency. Russell, I know you have a lot more to say on this.
Yeah, I mean, I've written on this myself, as Christian said. I mean, there's lots going on there, and I agree with everything that Asaf says. All I'd want to say is that for me, the International Committee of the Red Cross would be an international organization as we term it under international law. Now, I know it's an atypical international organization, and I've even had some quite confrontational debates with legal advisors at the ICRC as to whether it is an international organization or it isn't. But if you take the view that it is, and others do, including the ICTY, the International Criminal Tribunal for former Yugoslavia, then it suddenly becomes very significant, because international law seeks to protect that entity that qualifies as an international organization under law. So it gives them certain privileges, it gives them certain immunities, and this will protect, for example, their servers, it will protect their networks, and in particular, it will protect the very confidential and sensitive information that they are given by refugees, by displaced individuals, by those that are interned when the ICRC visits internment camps, etc. So, you know, I think that's really worth stressing. Of course, if the ICRC is an international organization under international law, it doesn't just benefit from the protection of international law, but of course, there are then certain obligations incumbent upon it. For example, it would have to comply with certain human rights obligations as well. So in that sense, you know, it's kind of a double-edged sword. But I think as the ICRC hack reveals, we need to be thinking about how we can protect the very important and the very brave work that these organizations are doing, in particular the ICRC, which is especially prominent at the moment, perhaps always has been. And certainly my own scholarship, and I know Asaf has through his work in this book, has tried to look and try to eke out as much protection as we can for these actors. Thank you, Christian.
And there's a question in the chat, and the way it looks in the chat, it looks rather long, so feel free to follow along as I read it. But it says that this area seems to be one that includes civilian actors more so than a lot of other war fighting activities, from using private contractors to vet/do background checks, partner forces to private cloud services and storage of the data on privately owned servers. And the question is, can you speak to the particular challenges and opportunities that come with this extensive civilian involvement? Because, we're touching on international organizations, some of which Russell just mentioned, have some different relationship to that a private civilian organization would have to the law. But can you speak on those particular challenges and opportunities that come with civilian involvement when it comes to privacy and data during conflict?
Yeah, this is a great question, and I'm so grateful it was asked. That is true. I will kind of premise this by saying that throughout the history of IHL, the involvement of civilian actors is kind of manifested in different ways and generated similar and different questions relating to the privatization of war efforts, relating to regulation of, so anything from the use of mercenaries to other kinds of security contractors, all the way to the development of military weaponry and its procurement and its utilization on the ground. So throughout the history of war, and certainly modern warfare has always had these engagements with civilian entities, and throughout the history of those involvements, it always generated questions of governance that were hard, in part because these entities are not subject to the same oversight mechanisms that state entities are, and are not elected officials who are beholden to the public. They're beholden to the shareholders, and that generates a different schemes of interest that might require different levers to be pulled in order to ensure that public interest is protected in the course of their activities. That is only heightened in the context of these, and I'll just highlight two challenges and two opportunities. But there are really, this is a topic for like a dissertation. This is a great topic to sink one's teeth into. So two challenges. One is the cross-border nature of the civilian activities, the civilian actors involved here. And so part of the problem is that we're no longer talking about only an American company working with the American military in a particular way. The reality is now that, and I used the example before of a soldier in a base. Now, if a soldier is on TikTok and TikTok is controlled in China, that introduces a whole set of jurisdictional challenges and the ability of American regulators, and we've seen that specifically in the context of the national security threats associated with TikTok activity, generates a lot of hard questions on how regulators in the US can regulate abroad. So that's one set of challenges. Another set of challenges has to do with the lack of centralization. It's not one actor or two actors. It's a whole sea of actors introducing new types of technologies and applications which generate interoperability issues. So what makes it so easy to hack and so hard to regulate is that there are so many different tech companies and so many different technologies, and each of them are subject to their own markets and competition within them, and to various complex regulation that tries to be tech neutral, but might as a result not capture the full spectrum of problems that say facial recognition technologies generate versus say surveillance from a drone generates. Here's two promises, or two places where good can come out of this. One is, so far, a lot of the human rights frameworks that we have been talking about had all kinds of exclusions, especially in the context of data protection, exclusion for intelligence purposes or national security purposes. So a lot of times states through their regulation have excluded the military and intelligence agencies from data protection regimes. But the entities that are not excluded are commercial entities. So what happens when a commercial entity contracts with the military? Well, now there's a window to rely on data protection in regulating the commercial entity as it's being utilized to develop a technology or deploy a technology for the military, because the commercial entity is not incentivized from creating two different technologies, one for the military unregulated, one for the rest of the world regulated. And so we might utilize the reliance on commercial entities to introduce data protection regulations on militaries through the back door. That's one. The second is that it introduces non-trivial ways to ensure regulation that does not come through a top-bottom convention or treaty amendment. It could come through the way the technologies are being designed. It can come through the corporate governance mechanisms. So if we rely on, and so the last slide I showed on that Rolodex included a particular strike that happened at Google, where all these Google employees came out and said, we're not willing to work with the Pentagon on an AI technology that could result in mass surveillance. And so they pushed their own company to pull out of that contract. Of course, ultimately that contract was still signed, and they chose the limits of what employee social and action, what the limits of that action is. But at the same time, it just demonstrates that there is possibilities to rely on new types of coalition actors in fights for digital rights in the context of military activity. That was a very long answer, I'm sorry, but it's a topic that really speaks to a lot of the things that I'm thinking about.
I would just say very briefly, I don't have too much to add, and perhaps it's a trite point, but I think it's one that's important to reiterate in the digital context, is that we need to move beyond this idea that when an armed conflict is occurring, that it is exclusively international humanitarian law that regulates the way in which the parties interact with each other, and also the way in which they interact with other entities, whether it's companies, whether it's civilians. Because in the vast majority of cases, the relationship between those parties to the armed conflict and to civilians will not be governed by humanitarian law, unless there's very specific context. It could be occupation, or of course those civilians are participating in hostilities. But outside of those, generally quite exceptional scenarios, it will be other rules of international law, human rights law, etc., that will govern the way that the parties interact with the civilians. And that's the same in the context of the right to privacy. So the right to privacy, civilians' right to privacy, can't just be bulldozed over by a party to an armed conflict saying, hey, it's an armed conflict, it's an emergency situation, we have free rein to do whatever we want. The reality is the assessment needs to be much more nuanced, and an assessment of a relationship between the party and the civilian's activities and their nexus to the armed conflict, in order to determine which legal framework applies. And of course, that legal framework will have a big impact upon the rights that the civilian enjoys. But 9 times out of 10, or the majority of times, it would be the case that it'd be the human rights law paradigm that would govern those interactions. And of course, the human rights law paradigm confers much more protection upon civilians than the humanitarian law would. So I think that's really important to bear in mind, because that analysis applies in the physical context as well as in the digital one.
Excellent. And Russell, what you were just speaking about is something that the book highlights, which is these 2 legal approaches for about this topic, but also the future regulation of privacy and data protection in war. So I know a lot of your answers, I could parse together to give what I think your answer would be, but those 2 legal approaches are one that extends the existing rules of IHL to cover new types of data intrusive activities by both militaries and other non-state groups involved in armed conflict, and the other that relies on the concurrent application of human rights law that you were just speaking to achieve similar effects. So I guess my question for both of you is, which of these 2 approaches do you find more persuasive, or is it not just, you just pick one approach, or is it trying to find a better relationship between the 2?
It'd be strange if we disagree, Asaf.
I doubt we will. We'll see.
Go ahead.
I think we need both, and I think both are necessary. I would add a third, and kind of that's what I was alluding to at the outset, which is that there will be more non-conventional ways of thinking about regulation of this issue. And so Lauren Lessig in Code 2.0 talks about this, about the role of markets and values and code as other forms of regulation alongside law in its kind of positivist doctrinal format. And so it's important to understand that we are setting regulation within an existing infrastructure set out by companies, set out by attack environment, and that by design already limits some of what we can do or opens up opportunities for things we couldn't have in the past done. And so we need to keep that in the back of our mind and not disassociate it from law so that we only talk about kind of legal regimes. That's it. Sticking with the two legal regimes, which are obviously the two available, we need to see what we can do within our existing IHL frameworks. And we also need to use this as an opportunity to reconceive concurrent application of human rights law in IHL. Now, I think that discussion, going back to nuclear weapon advisory opinion, and then the way it was discussed in the wall advisory opinion and in other examples, has kind of left this analogy, an analysis of lex specialis and lex generalis without kind of real meat on the bone. I always use the wall advisory opinion as an example, because in the wall advisory opinion, the ICJ acknowledges that the right to privacy under Article 17 of the ICCPR applies in the Palestinian territories, applies in the context of armed conflict, but then says nothing about how or the meaning of its concurrent application as it relates to the issue at hand, which was the construction of the security barrier. That's not good enough. I think that we need to move the needle on that discussion. And so I think that privacy and data protection offer a great example for human rights law, in my view, clearly applies as in concurrent ways, because IHL is oftentimes simply silent in ways that were not intentionally silent. They were just never addressed. And so the lex generalis of human rights law has to fill in those gaps. But we need to discuss meaningfully how they fill those gaps. What is the scope of application of those human rights, even if we said that they applied in times of armed conflict? Is it merely a pick up, copy, paste, and dump it in an IHL context? Or are there any challenges and issues in the way they apply, taking into account the particular circumstances that are generated by an ongoing protracted violence? And I think those are real questions. And that the discussion around concurrent application has not oftentimes run the full gamut of exploring those. So are we in disagreement, Russell?
I don't think we're in disagreement at all. Just moving beyond the law for the moment, I also think there's a cultural observation that needs to be made here, which is about inculcating the rights to privacy, the right to data protection, as well as others, into the language of armed conflict, so that we do finally once and for all move away from this paradigm that there is a law of peace and a law of war, and in one there's all this regulation, in the other everything is fair and everything goes, and it's kind of a wild west. Now, I know that we have moved to a certain extent beyond that, but as I've said, it's the lack of granularity that is missing, and we need to think about what's missing in the law, and that's a call to the humanitarian community to tell us as international lawyers, or perhaps more over the policymakers, what protections they need, what's going to be useful on the ground, what can enable them to do their jobs most effectively and ensure protection. But it's also directed across the spectrum. So militaries as well. Asaf and I have been doing some work at the moment, which is trying to get militaries to write human rights protections into their military codes. So for those who have been in the military, have any understanding of the military, most states will produce fairly comprehensive documents which guide the conduct of their forces during times of armed conflict. Now, if you pick up the UK one, you'll see lots of discussion in there about the physical protections and the physical acts that the UK military forces can do, and in particular types of physical protections they must confer upon civilians. But what about digital rights? What about the right to privacy? What about the data protection? So perhaps we can try to build from the ground up, so we get the inculcation of the digital rights into in a cultural sense into the discourse. Then we can start to build it up through states, up through their military manuals, so it starts to gain some traction in international. But really, I think the humanitarian community is going to be absolutely critical to pushing that conversation forward.
Another question we got in the chat, and it's based off everything you both are saying right now, is one thing that often comes up during the conversation about the protection of privacy in armed conflict is the question of whether data is an object. And if so, whether it is a legal military objective or a civilian object. from what this person is interpreting, your focus seems to be around the human right aspect of it. So it would be interesting to hear how you think about the data itself and how that factors into the analysis, if it does in any way.
Yeah. So this is a huge topic, and one that has generated a lot of disagreement. I was just at American University at a conference that had Michael Schmidt on one side and Ori Pomson on the other. Ori Pomson representing in this discussion also Israeli views around these issues. And so what I think is interesting to this audience, who probably is more familiar with military objective, data as a military objective question, is also that there's parallel questions that exist outside of IHL and IHRL and international law more broadly that parallel this discussion. They have to do with whether data is property, and how do we conceptualize ownership over data, and who can be said, and so that ties to questions of tangibility. How do we conceptualize data? Is it a thing that can be copied and pasted, and if so, is it really a thing, and subject to kind of the concept of thinghood over which ownership could even be possessed? So there's a lot of in philosophical and legal discourses, conceptualizations of data that I think are feeding into some of the analysis. And I can tell you that in our book, the chapter by Eric Jensen and Lori Lang touches on that. They take the assumption the data can be owned and the data can be a subject to some of IHL's regulations in that way. And they have a footnote that kind of cites to some sources in this regard. But it's a far from settled question. My personal view is to say that I think that it is inevitable that we think about data as one for which we are entitled to certain protections about, because the result is that if data cannot be owned, is not subject to our property-based protections, then it is only the proprietary power, subject to the proprietary power of the corporations, who can decide what to do with it as they please. And we've seen the ramifications and effects of that. And so even if current conceptions of law and current conceptions of our existing rules stop short of defining it as such, I think the world we're moving into, where if everything that we act and do is datafied, is subject to manifestation in data, and the future of that is the metaverse, where every activity we'll do will have a data generation nature, then what we do has to be subject to some property protections. Otherwise, the result will be that we will live in an ever-ending state of surveillance. But that's personal opinion. It has nothing to do with where the law necessarily is.
And I'll just come in very quickly there and say, I think the general trajectory of discussion or debate is increasingly recognizing data as an object for some of the reasons that Asaf has alluded to. But as Mary Ellen says, and I just picked up the book just to check to make sure I wasn't misquoting her, as she says in her chapter, she also discusses whether data can be a military object. She makes an extremely prescient point, which is that even if we say that data can't be an object and therefore doesn't benefit from some of the protections that IHL would afford, it would still, it wouldn't become a free-for-all. It would still enjoy the protections afforded under normal human rights law, which would be considerable. So, sometimes I feel that this discussion or this obsession with whether data is a military object or not, again falls into this paradigm that it's either IHL either protects entirely or it doesn't protect it at all. IHL is part of an integrated framework of public international law, and there's systemic integration between those legal regimes. So yeah, if IHL doesn't provide the necessary protection because data isn't an object, I think it is. But if it isn't, then international law protects itself, and then other regimes will come into play.
Excellent. Well, we're running close to the end of the hour, and I can tell, I think, from your room, Russell, that the sun is starting to set on your side of the world. But I just wanted to ask one more question, since the beginning of our topic was based on the book. Is there anything that you wish the book would have further explored? and maybe what can we expect in the second edition, perhaps?
Yeah, so I can tell you that the book offers a canvassing exercise. In that regard, it doesn't offer answers, it raises questions more often than it solves problems. And I think that the next steps in this discourse has to be an analysis of the way militaries in practice are engaging with these questions. And partially that will come in the form of what we started to talk about, what Russell started to talk about with regards to whether or not some of this language will get incorporated into military manuals of the future. I can tell you that you'd be surprised. There is a receptive audience out there within militaries to some of the ramifications of the book. But it starts somewhere, right? So it starts with them worrying about their own soldiers and or coalition forces activities. But even if we just operated within those circles, I think that there's so much that could be said. And that could then open the doors to far more complicated discussions about how privacy applies to, say, the detainees or the enemy, or to, say, targeting operations. And so I think the next step for this, and I can tell you that I should note, by the way, that the entity that funded this project is NATO's Cybersecurity Center of Excellence, right? So NATO is very interested in these questions, and they are continuing to explore new ways to continue the conversation on these topics at CCDCOE. So it's not out of the question. There will be more research coming out of this along these veins.
And I would just finish that by saying that you tell us if there's anything missing, as the humanitarians that are doing the work on the ground, and dealing with the difficult issues. Is there something that that academics, particularly international lawyers, need to be taking more seriously? Is it this? I know the ICRC is very much interested in the digital emblem and how the digital emblem can be used. Whether there can be digital embassies that can be used to store very sensitive data, health data from refugees, or information on terrorists, for example. So is this needed? Is this something that would help your day-to-day work? Would it improve things on the ground? So for those of you that are listening, if you read the book and you think there's something really missing, then either do the research yourself or reach out to Asaf or me, and we'll be happy to take those conversations forward. I think it needs to be a bottom-up approach as well as a top-down one.
Exactly. And so I appreciate both of your time again for joining us. I found this topic incredibly interesting. It's something that I knew very little about, and just like Asaf said, the book does provide a lot of provoking questions, but you don't reach answers until a question is asked and presented to you to think about and to contemplate. So again, the book is The Right to Privacy. Seem to have gone off mute for a second, but I put the link to the book again. I encourage everyone to take a look at it. It's written very well, where you can open it one day, read an article, and then a couple of days later you can start in the next chapter, as the authors are all different in each of the chapters. So thank you so much again. I hope to see both of you again soon in similar circles to have further conversations on this important topic. So take care, and thank you all again for joining us.